My name is Helen Goldstein. I am an attorney at Procopio, and I do a lot of my work in the area of licensing and tech transactions. So that would be any kind of commercial transactions that you are going to do. And mostly the kind of work that I do is usually with companies whose primary value proposition is kind of very IP focused, very focused on intellectual property as opposed to kind of hard assets. This is Licensing and Tech Transactions 101. It's one of my favorite subjects to talk about just because every single agreement that I do seems to have its own little and interesting quirk. It's always fascinating to learn all about the kind of technologies that my clients are developing, right from very complicated medical devices all the way through to some of the latest AI. Really, I wanted to start with this idea, call it beyond the widget. I think that it's pretty rare for me to work on deals that are about, we are making widgets. We've made widgets for 100 years. We will continue to make widgets for another 100 years, and everyone knows how to make them, and we just happen to make them efficiently. Really, most of what I do and most of what the startups that I'm working on do are really far beyond this stage. They are dealing with IP, and they are dealing with concepts and ideas and products that there's no way people would have even thought about maybe 10 years ago, 20 years ago, or maybe even more recently. So most of what I'm going to talk about today, I'm going to try and focus it more towards that emerging technology market, but definitely so many of the principles that I'm going to talk about would be applicable to things which are not so new and shiny and out of the box. So I wanted to start with this idea. I think that it's always important to kind of start from a baseline just so that I make sure that everyone is on the same page as me. And also I find sometimes that kind of we're missing like little bits of information. And so if I can give like a full picture, it'll kind of help you tie it all together. So let's start with this concept, assets and what to do with them. So really everything that your business has, every piece of property, whether that be a tangible piece of property like a pen, a phone, glasses, anything that your business owns, it can be tangible, but it can also be intangible. It can be the inventions that you have. It can be the software that you've written. All of these things are assets. And there's a few different things that you can do with your assets. To put it very simply, create assets, change assets, you can transfer assets, and you can allow someone to use your assets. And depending on whether you're dealing with something tangible, physical, or whether you're dealing with something intangible, like a patent or a piece of software, all of these different concepts apply. So for example, if someone is developing a piece of code, intangible assets, right? I'll often start with a development services agreement, or maybe just a services agreement, right? Someone is manufacturing the latest and greatest robot, right? This is a genius AI robot. I might have a manufacturing agreement for that, right? This is anything where I'm taking an asset and I'm creating it or I'm changing it. So usually these are services that someone else is doing with your IP, and you will actually license them your IP in order that they can do these services with them. Just to put a couple of concepts together. Transfer. This is pretty simple. You can sell stuff. It's easier to sell your tangible IP than your intangible IP. And you want to be really careful when you're transferring intangible IP, because it's really easy to transfer more than you ever thought you were going to do. But a purchase agreement, a supply agreement, where someone is manufacturing something and they're going to transfer it into your ownership. A distribution agreement is kind of like a transfer. It'll go manufacturer, then it'll switch, and then it'll fall to distributor, and then it'll fall to customer, right? Sometimes I have companies that really don't even ever touch their products. They'll be manufactured offshore. They will come into the US. They will go to a third-party logistics warehouse maybe, and from there they will be distributed out to customers. So a lot of things that you can do in terms of tech transfer and licensing might actually be connected to a distribution agreement. The last one is allowing someone to use one of your assets. Now, oftentimes we'll call that a lease, and a lease can apply both to tangible equipment as well as property. I'm sure you're aware of being able to lease a piece of property, but you can also lease equipment, right? And license, which is kind of the one that we're going to focus on the most today, which applies largely to intangible assets. Although when you go to the cinema, you actually get a license for the seat that you are sitting in. Crazy, no? So let's take this concept one step further. And in all of those different relationships that I just talked about, creating or changing an asset, transferring an asset, oftentimes you will find that there are also licenses baked into that. So for example, let's take your latest and greatest robot that you are going to produce. So you might have some patents, you might have some software, some firmware that's integrated into this tangible product, and you've decided that you are going to make this product in a manufacturing facility in Japan. So you're going to hook up with that Japanese company, and not only will you have a manufacturing agreement, but buried in that manufacturing agreement will be licenses, because you will need to give them the right to use your IP in order to produce the services that they want you to produce. And let's think about this the other way also. Some of you might run service companies yourself, where you are the ones who are doing the developing. You are the ones who are doing creating for clients. In that case, it's kind of important that you get a license to the raw materials, be that tangible or the raw IP that you are going to use in order to produce those services. So whenever we're talking about a license, I think there are a few key areas, and I'm going to start with the concept of the scope of a license. The scope of a license is basically me telling you exactly how you are allowed to use that which I have given you. So in terms of tangible property, do you remember I said about the cinema seats? A cinema will license you the right to use that seat to watch a movie. That is what you're licensed for, right? In terms of licensing your IP to a manufacturer who's going to create product, think about the restrictions that you're going to put on that. You would not want to give them a completely unrestricted license. Like, yeah, I'll give you a license to my IP, no problem, go for it. You want to say to them, I'm giving you this IP for a reason. What's the reason? I'm giving it to you so that you can manufacture this thing for me. Don't you dare use it to do anything else, right? And I often joke that, like, whenever I'm writing an agreement, in my head, I'll sound like a human, and then it comes out in lawyer, right? Don't you dare would be something like, you will have the right to use this solely to manufacture the products and produce and perform the services described hereunder. You are prohibited from using the licensed IP for any other purpose, right? Basically a don't you dare. So whenever we're doing these kind of licenses, scope is important. It's almost like you're kind of taking a fence and you're kind of building your fence with exactly the right boundaries. And this is really helpful, not just because you don't want someone to misappropriate your property to use it in a way that you didn't want them to, but also because it means that I can do different things with my property. It means that I can basically multiple the revenue that I might get from a piece of IP, even if I've licensed it to someone already. So, for example, if I have licensed with one particular set of restrictions, it still leaves me all this space outside of the restrictions that I might be able to license to someone else. So let me give you some examples of this. Exclusivity. Exclusivity is a big topic in licenses. To say that a license is exclusive means basically that only that person can use it. An exclusive license is infinitely more valuable than a non-exclusive license. A non-exclusive license is, I'm giving you the right to use it, but everyone else can use it too. You know, I can use it, and other people who I license it to can use it. It is not exclusive to you. An exclusive license is I'm licensing it just to you. And as an extra tweak, I might also say the license is exclusive even to the licensor. In other words, I can't even use this IP. I created this IP and now I am licensing it to you, and I can't even use this. This is really helpful. For example, when you are doing a distribution deal and you want to hire someone in a different country who is going to take your product and sell it, they might want from you some kind of guarantee that they have absolutely exclusive rights to it, and not even you can go in and use the IP in that particular country. So exclusivity is the first one. Either it's exclusive or it's non-exclusive. The next one, price, obviously. Show me the money. And I'm going to talk about it a little bit more later, but how much is the person paying for it? Sub-licensable. If you grant a license, you can say it is or it is not sub-licensable, and you should absolutely make sure that you put in your agreements whether or not it is sub-licensable, because if you don't, the default in most jurisdictions is that it can be sub-licensed. And for many people, that is not something that they want. If they have licensed their IP to someone, they will want only that person to use it. So for example, let's say you have licensed your IP to a manufacturer. You do not want that manufacturer sharing your IP with someone else, because you might be trying to keep the trade secrets and the value of that IP. You might want to try and keep it in one place. So always make sure that you put down whether or not it's sub-licensable or not. Scope of the type of activities. So you can say you can use it for manufacturing. You can use it to perform the services that I've contracted you to do. Or you could say you can use it for any purpose, right? So there are lots of different ways. And if you think about all of the different ways that your IP might be able to be used, then by breaking it down by activity, you might be able to, for example, license it to one person in the veterinary field, one person in the medical field. And there's a little bit of overlap here with field also. So I just used the word. In terms of field, this is usually used to kind of describe the industry that someone is working in. And in life sciences, oftentimes field is used to describe the indications or the therapeutic area. So for example, a few days ago, I was dealing with a license, and it was a license for a piece of a patent that was coming out of a California university. And the particular therapeutic could be used in the oncology space, but it could also be used in the renal space. So it can be used for a few different kind of areas. So what had actually happened in this case was there was one company that had it for oncology, one company that had it for a different indication, another company that had it for a different indication. And even finer than that, we had some indications that were broken down by how the drug was administered. Was it dermal? Was it IV? So there's lots of ways in which you can craft a license. The last one is territory, and territory is usually used to describe a geographical area. So the United States of America, it could be the European Union. Whenever you do this, please just be as specific as possible, because generally saying America could mean a lot of different things. So what we want to do is we always want to make sure, particularly when we're describing territory, that's where I see it most. That's where I see most of the kind of the vague terms come in. Oftentimes, as I said, I see America or I see Asia. What does that mean? Because there are lots of different definitions about where that ends. Europe. There are lots of different ways in which people would define the contours of what is Europe. So I wanted to give you some examples of what this looks like in scary legal language, just because I think that it's really helpful to try and pick out some of these concepts and see what they look like in context. And it's going to help you spot this. Let's take a look at the first one. This one is actually Gilead and Tibotec. So this is more in kind of the therapeutic space. Tibotec hereby grants to Gilead a co-exclusive with Tibotec, i.e. only Tibotec and Gilead can use this. royalty free, as in you don't have to pay for it, with the right to grant sub-licenses to the extent permitted under, so there were some restrictions, under the Tibotech technology. So that's a defined term here. And you'll find somewhere else in the agreement where it's defined solely to conduct commercialization activities, i.e. I'm limiting your activities. And then in the field, in the territory, those are defined terms. So somewhere else in the agreement, it should say field means XYZ. Territory means XYZ. You want to be really careful and make sure that if you put defined terms in your agreement, or you see defined terms in an agreement, that they actually do have definitions attached. Because otherwise, this just means nothing. In the field, which field? The green one out the back of your farm? I don't know. Let's look at the second one. Subject to the terms and conditions of this agreement, Monsanto, people probably recognize that name, hereby grants to Allium and its affiliates a non-exclusive. So remember, this means I can grant it to lots of other people, royalty-free, fully paid, again, no charges for this, sub-licensable, you can sub-license it, transferable, you could actually wholly transfer this license worldwide. You can take it everywhere, right? License under and to use any and all Monsanto improvements. There's a defined term. So somewhere else in the agreement, there'll be a description of the Monsanto improvements for all purposes outside the agricultural field. That's because Monsanto probably want to hold its IP for its own use in the agricultural field. Here's the last one. Scientix hereby grants to licensee a non-exclusive, again, non-exclusive license in the territory. That will be a defined term. We'll find the definition of territory somewhere else. Here are licenses to make and have made, import, to use, and offer for sale, and to sell. We lawyers, if we can say something with many, many different descriptions, I feel like sometimes we do. There's kind of there's almost like a lingo to describing the type of license where you can pretty much do everything. So things like to offer for sale and to sell, to make and have made, when you see that language, usually it means that the person is being granted a license to do whatever they want with this IP. I told you I talk about money. Very important, right? I think that a lot of times I get asked by people, is this a fair price? Is this a fair price? I am in licensing. I am getting IP from someone else, and I'm trying to work out whether or not I am paying a fair price for that. So licenses can be structured in lots of different creative ways, and particularly in some of the with a lot of the life science clients that I work with, and that's one of my areas of focus, you will find very complex terms on how a licensee, someone who's receiving the IP, pays for the privilege of using that IP. Generally, there's kind of three modalities here. The easiest one to understand is upfront fees. This is you pay me an amount upfront. Could be a nominal amount, and I usually suggest that it's good to start off with a really small upfront fee, because it kind of like kicks off the relationship. It's like you paid the fee, you're good to go, and everyone kind of feels like that's the kickoff of the relationship. In between, you might have various milestones, and this is particularly important in life sciences, where a product will go through multiple phases of development, and sometimes, and as it goes through that development, it de-risks. It basically becomes more of a sure bet that something might actually come of this amazing idea that someone had. So you might have milestone payments. They might be connected to clinical trials, for example. But you could have milestone payments with respect to simple commercialization. Let's say someone licenses you a piece of software, and your milestones are 300 users, 2,000 users, 3 million users. Could be milestones like that. Royalties are another way in which you can do this. Royalties are usually a percentage of what you are taking in, sometimes in revenue, sometimes in net profits. It is so important when you are dealing with royalties to make sure that you know how the number is being calculated, because it's really easy to say, oh yeah, we're going to take 5% of net sales. Well, what does that mean? Well, it's just, your profit. What you're taking off the top. Well, does that include these costs? all these taxes. They include these fees. So it's pretty important whenever you are doing a deal with royalties to just make sure that all the parties are actually and literally on the same page, as in everybody has an actual business understanding of what the agreement is, and whatever is written on the piece of paper actually reflects that agreement. There is no point having an agreement that doesn't actually reflect what you are going to do and what you have agreed. And it blows my mind regularly when people are like, yeah, we have this agreement, but that's not what we actually do. And I'm like, so what? Why did you write it? Why write it? It's not what you're actually doing, right? So let's just make sure that our business agreements actually end up with what's on paper. And I'll say also that sometimes people feel like, maybe we'll just try and sneak this one past. We'll kind of hide it and we'll try and sneak it past. We think it means one thing, but someone else thinks it means another thing. I guess there could be some times in which you might want to play that game, but it's pretty risky because at the end of the day, having an agreement, particularly in the IP space, when people are actually at different tables on completely different pages in completely different rooms, it's just asking for litigation. It's just asking for misery and argument down the line. And what you would have saved actually being clear on paper, you could end up paying to some of my litigation colleagues to sort it out in court. The other thing I wanted to say in terms of money is that I often ask my clients, what is the market opportunity here? How much do you think you are going to walk away with in pure profits after you have spent all the money developing this really cool IP that you licensed in? What is the market opportunity here? And then whatever that amount is, now decide what percentage you think the person who is licensing you the IP deserves, or if you're the licensor, how much you think you deserve. And then maybe you can break it down between these different subjects, because if you ask for everything as an upfront fee, you'll actually probably get less, because an upfront fee is a sure thing, it's low risk. But if you push into royalties, you might actually get more if you're the licensor at the end of the day. It comes with a higher risk, because if it never makes it to market, you might not get anything at all. So just always have in mind that there is, at the end of the day, a market opportunity, and this is your way of allocating the risks and the benefits of being able to exploit that market opportunity. Buckets of IP. I don't know why they're called buckets, but definitely when I went to American law school, they were called buckets, and all of my hardcore IP colleagues call them buckets. So buckets they are. Buckets of IP. This basically means that there are different categories of IP, of intellectual property, that'll flow in and out of a license. So the first is what the parties bring to the deal. This is often called background IP or pre-existing IP. Those are usually the defined terms that I'll use in my agreements. So it could be client background IP if I'm working for a service company, right? It might be company background IP, actress background IP, or it might just be generic and say the IP of the parties outside of the scope that was developed outside of the scope of this agreement, prior to or outside of the scope of this agreement. So background IP is what people are bringing to the table. And most of the time, people hold on to their background IP, and it's this which is licensed. Not always, but most of the time. The IP that's created during the agreement, during the services or whatever activity that's happening, is often called foreground IP or a rising IP. Literally, IP that is created by taking the background IP and performing services on it, or taking the background IP of two people and putting it together and doing some kind of collaboration. With these buckets of IP, you can kind of split them up. And I've done plenty of deals where I've had foreground IP that's created and there's background IP that's there. And you'll see the contract reads, background IP, title stays with the person who brought it. Foreground IP, if it's connected to this use, then it'll go to this party. If it's connected to this, then it'll go to this party. If it's not connected to anything, then we're going to split it jointly. Ideally, joint ownership of a rising IP can be a bit of a minefield. So I would always recommend trying to assign a rising IP ownership to a particular party. And if you do split it up, just have that concept of joint IP being in kind of like a catch-all, right? That you generally think that all of the arising IP has gone out and has been assigned, has been transferred to people. But just in case, you're going to have kind of this fallback. So let me give you an example. There is a collaboration. Two parties bring software code to the collaboration, and they both take their software code, they put it together, and between them, they take some of the concepts of one, some of the concepts of the other, and they create a new piece of code, And they say the code which is generally related to non-AI functions, that's going to party one. The code that is related to AI functions, party two is going to own that. And usually what you'll see is cross licenses back. So even though party one owns this IP and party two owns this IP, you might see them say, we license it back to you also. So you could have a license, it'll be probably non-exclusive, royalty-free, etc., etc. However, you might also just have a just in case category of, and for all other IP, will be owned jointly. Identification is a minefield. I think because it is one of the hardest areas of the contract to understand, because it uses a lot of words that are just not common outside of legal contracts, but it also is one of the areas of the largest risk, because not only are you sometimes promising that the other person, that you won't breach the agreement and cause the other party damages, it might say, if a third party comes along and sues the other party because of something that you did, you're on the hook for that. So it'll involve third parties also. And particularly when we're dealing with IP and IP infringement, these cases can be massive. The damages could be huge. So I definitely think that it is worth, when you have a contract that comes over and it has this big scary word, indemnification, it's definitely important to make sure that you have legal counsel who can explain to you what that means and the implications and how big the risk is, and maybe talk you through ways in which you can minimize that risk, because there are ways. So I wanted to show you what indemnification sometimes looks like in these agreements. So here's the first one. This came out of a franchise agreement, right? So something like McDonald's, right? Where McDonald's has licensed the marks to a local McDonald's so that the local franchisee can put up those golden arches. So a franchisor will indemnify and hold franchisee harmless. Well, that's a lot of legal language. Basically, the franchisee, if the franchisee is harmed, then the franchisor is going to step in and it's going to cover those losses. When is it going to do that? It's going to do that if the franchisee's use of the marks in accordance with this agreement infringes the rights of any third party unrelated to the franchisee. So if I have licensed you my trademarks and someone comes along and says, hang on a minute, you're infringing on my trademark, you're like, no. Helen licensed it to me. She said I had the right to do it. And they're like, well, that's not the case. I actually own this trademark. I'm going to sue you. You would be well within your rights to come to me and say, Helen, what's up? What do you mean? You licensed me these marks and you said that you would indemnify me and hold me harmless. This person, they're telling me that actually I'm infringing and now they're suing me. You're on the hook. Here's another indemnification clause that I pulled out of my favorite industry, life sciences. This was from a collaboration agreement. So in these collaboration agreements, you'll often see complicated terms because both parties are acting with the IP at the same time. So here you've got an entity is going to indemnify and hold harmless the licensees and its affiliates and sub-licensees and lots of other people connected with the licensees from the liabilities from third-party claims arising out of the exploitation. And usually it'll describe what it means by exploitation. So the exploitation of any collaboration products, that's probably products that the parties have developed as part of the collaboration that they undertook. What have we got also? As a result of ongoing clinical studies conducted unilaterally, gross negligence or willful misconduct, that's a very common place to see indemnification. Breach, that's fair, right? Violation of applicable law in connection with the activities. That's fair. Or product liability arising from, etc., etc. So that's what kind of a indemnification clause looks like. Can be super complicated, but well worth your time to understand what you are promising. I wanted to end the me talking a lot part of this by talking about what I like to call the stupid stuff. I do a lot of mergers and acquisitions also. I'm kind of a little bit like triple trouble. I do startup work, I do all of this tech licensing work, and then oftentimes I have the privilege of selling my clients to people who are buying them, hopefully for a lot of money so that my founders can go on and start new companies, or sometimes just buy their own tropical islands, whatever they fancy. So I always like to share what I call the stupid stuff, which is things which is so easy for you to get right. You don't need to pay a lawyer to do it, but when you sell your company, will be worth potentially millions. Here's the first one. Correct legal names. I cannot tell you the number of times that people call me Hannah. I don't know what it is. Hannah should be my Starbucks name, right? My name is Helen Goldstein. If you wrote Hannah Goldstein agrees that Hannah Goldstein will license me, who's Hannah Goldstein? When it comes to selling your business and they're like, I see you licensed your core IP from Hannah Goldstein. Who is that? And you say, oh, Hannah actually was meant to read Helen. I come along and I'm like, I know what you're talking about. I'm Helen Goldstein, not Hannah Goldstein. But the number of times that we don't drop in the correct legal names, that's a simple example. But making sure that the company that you are doing your deal with, they're using their correct legal name, not what they think they're called or what one of their divisions is called. What are they legally? Because just like you have human persons, your entities are legal persons and they need to be identified correctly. And usually we do that by saying the name of the company will then say the state that it's either formed in or incorporated in and what it is. So for example, Helen Goldstein Ventures Incorporated, a Delaware corporation. I see a lot of times the parties kind of get tired of negotiating about things and they're like, yeah, we'll just agree in the future that we'll agree to this. You know, we don't really know what's happening right now. So we'll just drop in there to save us having to think about this. And at the point at which we've created a viable product, we'll agree as to the fees connected therewith. An agreement to agree is not legally binding. You can't walk up to someone and say, hang on a minute, you agreed to agree with me, and now you're not agreeing with me. That's it. I'm done with you. I'm going to sue you. No, you're going to get that. You're going to get to court, and the judge is going to go, yeah, can't force someone to agree with you, however much we want to. Here's the next one. Fully executed. This means that all the parties, all the people who are making agreements in this document have signed on the line. If there is a line in your agreement and it does not have a signature on it, ask yourself why. Usually they all need to be signed. Uploading a partially executed document to a data room in connection with the sale of your business is just not going to be accepted by the buyer, because the buyer is going to want to know that the other side signed it. And if you cannot show that, then it's kind of like it's not really worth the paper that it's written on. You really need fully executed agreements. So after all of the work that you do to find this potential partner, to negotiate the agreement, sometimes to pay lawyers to go backwards and forwards with track changes and red lines, and then you argue over the tiny little details, and then you sign it, and you never bother to get a signed version back from the other side. There was no point. Signing on the dotted line, well, it's usually a non-dotted line nowadays, very important. Here's the last one. Saved where you can find it. Yes, the number of times that my clients have told me, yeah, we have the fully executed version. I have no idea where it is. Especially with core IP that you might in-license at the very beginning of your journey. You might have that license for 20 years. In 20 years' time, are you going to remember that you saved it in your downloads folder in like a random place and you called it fully executed? No. And by the way, you're totally going to throw out that laptop somewhere between the point at which you sign the agreement and you sell your company, hopefully for millions. So save it where you can find it. this is my stupid stuff. I wanted to finish by thanking you for coming and listening to the webinar. I hope I made this subject somewhat interesting and entertaining. And if not, at least you got to listen to me and my English accent for a while. It's a really, really interesting area of law to practice in. Love helping my clients with this stuff, because this is how my clients get IP, do amazing things with it, and then use it to oftentimes save lives or completely change the way that businesses are working, completely change the world, the way the world is turning. I absolutely love it. And anytime you would like to reach out, happy to hear what you're up to and see if I can help. Thank you so much for your time.